got for tonight, and that way you don't have to look at me all evening. So it's lovely to meet you and to share a little bit about our organisation, and also share with you some of the challenge that we find as a relatively small organisation when it comes to delivering legal practice, as well as managing the commercial imperative of our organisation. The bit about BEF. So BEF stands for the Business Enterprise Fund. I think I need to be, sorry, I think I need to be letting some people in, I think. Hang on a minute. I'm trying to do everything all at once, so apologies for that. And go back to the slides. There we go. So BEF started 20 years ago as a small enterprise agency operating in the north of England, in Bradford, as part of the Thatcher years, in some of the most post-industrial, most disadvantaged areas. They were given an opportunity to set up these enterprise agencies to support the economic growth of those organisations and those areas. I'll come on to what we actually do in a moment, but just as part of the headline figures, in the last few years, we've lent nearly 132 million, which I think by London standards isn't a huge amount. It's still quite a lot for us as a small social enterprise, but that's delivered £580 million worth of economic growth in the regions. We have a small team of 35 staff that operate across the whole of the UK. Most of the locations we have are in the north of England, but that doesn't stop us delivering loans as far south as Brighton. And in fact, we're just doing a loan to a London pub at the moment. So we cover the whole area. Fish and chip shop in Cornwall as well, we've done recently. And we lend up to £250,000, and we currently manage funds of around 100 million. And as Gaynor said, the reason why we exist as an organisation is to transform poorer communities for the better. And we do that by encouraging the startup and growth of small businesses, who in turn employ people and create economic wealth. So to the subject for tonight, managing the challenges of commerciality along with their legal duty to their employer. In other words, considering the complex tensions of commerciality versus your duty to being a full legal service provider to your employer. We're going to look at some of those challenges of managing commerciality. And we're also going to look at some of the tensions that exist as being a single person or a small team full service provider, especially when you have to cover so many different aspects of the law. We'll touch on those a little bit later, but I want to give you notice. If you want to ask some questions at the end, you can do. I don't guarantee I will give you the best answers. My head of the legal team at the moment was supposed to be joining us, but hasn't done so yet, so I'm wondering where he's got to. Hopefully he would have fielded those questions, but I'll do my best. The one thing as well, if I am controversial, it's not because I want to be controversial, it's because that is our lived experience. So if I say anything that touches a nerve, please don't take it as a dig. It's just the reality of what we experience in our work. I'm not going to go through the list here, but I just wanted to touch on some of the general principles that apply to in-house counsel and in-house legal team. And you can see there that those general principles you will be familiar with. and experience those on a day-to-day basis. And I'm pretty sure that they will apply to most industry sectors. And ours is no different. However, we have another set of principles that we have to deal with, that we are legally obliged to provide. And that's because we are a regulated firm with the Financial Conduct Authority. Now, you will notice that the list of principles are pretty similar to the general ones. However, a couple of other things prevail, and I draw your attention to those. The customer interests, the conflict of interest, and the consumer duty are particularly tricky for in-house law firms when it comes to dealing with some of the legal aspects of the financial services sector, largely because some of the, and I'll touch on these a bit later when we get into some of the detail, some of the principles we have to abide by the FCA are not necessarily the best principles or the best outcomes that we as a legal firm would like. But I'll touch on those a bit later. But it just goes to show that there are tensions and there is a real balancing act that needs to take place. The role of an in-house counsel can be tricky, and that balancing act is sometimes tricky to achieve. But we're going to touch on a few different pulleys and levers that we can use in the role just to enable us to achieve the best outcomes possible. But first of all, I want us to consider the challenge of the balancing act. And as you can see there, again, not an exhaustive list at all, but something that anybody who operates as an in-house lawyer will be familiar with. And depending on how large the team, some resonate more than others. And in respect to the first one, time pressures, in our organisation, there are two of us who deal on the legal side of it, with somebody who assists on issuing court proceedings and so on. So it's not a large team. But one of the major issues on time is often you don't know when a court case is going to apply. You're at the mercy of the courts, and everybody's familiar with this. But we end up having to put a huge amount of resource in at very short notice. We do all our in-house, we do all our own work, we do all our own court cases, everything, all in-house. So it's a very varied role, but as you will imagine, trying to do case management alongside the general day-to-day job can be quite tricky. And on occasions, it can lead to certain bad outcomes if you're not careful. I can remember one particular case where some of the respondents were managing their own case, and they ended up appearing at the court earlier than our team, and managed to get the court to get the case thrown out because we'd not received notice that the time had changed. Thankfully, we were able to rectify that, but you can imagine some of the challenges that you face when you're doing that. The other big challenge is specialist expertise. And every in-house lawyer is expected to be an expert in everything, which, you know, is not possible. In our world, we have such a varied level of work that we do that it's quite breathtaking for such a small organization. So you'll have the general stuff, contract, employment law, but we then get into very complex financial structures and the banking finance that goes with that. through to some of the challenges relating to corporate law and shareholder interests, member interests, all the way to European law because of some of the work that we do on European structural funds. So it's vast and it's wide and it's varied. We cannot be experts in everything, but what we've found over the years, we have become quite good and quite knowledgeable in a lot of areas. And the longer we do this job, the more knowledgeable we become. Resources. And because we have such a small team, we have to manage those resources particularly well. And sometimes we end up having to subcontract to external legal firms some of the work that we do, but we have to be very careful how we do that, largely because of the costs that are attached to that. Now, I'm familiar that some larger organizations, essentially the in-house law firm, just spends most of their time liaising with external firms. We tend to do it the other way around. We do everything in-house if we can, and only when it's absolutely necessary do we look to subcontract that work to other firms. We'll touch on some of the other tensions when it comes to doing that, but I'll just throw this out there as one of those potentially controversial comments. But sometimes we find that the advice we receive from external firms is not necessarily as good as the advice we would have internally, but we'll discuss that later maybe. And the other thing that we've noticed and can rankle considerably, and we have found this in a more recent live example, is the fees and how external firms, how they vary so vastly. And because we deal with a number of external firms, we find it quite hard to justify how one firm can charge one fee versus another firm charging another fee, and it's essentially doing the same piece of work. I'm sure some of you more experienced in subbing out to other firms can give a good rationale for that, but it's a constant source of irritation to us, the variety of costs that are attached with subbing out to other legal firms. My colleague is constantly telling me how much I need to increase his salary to justify it, but that's another subject for another day. Moving on to the balancing act that we were talking about, I want to touch on some of the aspects of managing those tensions. And I've just realised that I've missed a particular line up there, but I'll explain that in a minute on the first one. But managing those tensions, one of the things that we've observed over the years is that being an in-house lawyer is more than being a lawyer. And I was at a meeting this morning and was talking to a few of local law firms to us, and we were talking about the place of AI and the development of the legal firm in the future. And it's quite clear that much of being a lawyer these days is not just about being able to give an opinion about a particular legal case, especially when much of the advice and much of the legal work is pretty standard. And we can argue the percentages. The guys we were talking to this morning said 80-20, another guy said 90-10. You know, as 90% is pretty bog standard, 10% is more tricky, another one said maybe 80 or 20. The point really is this, that we need to be able to add more to the role of a lawyer, especially an in-house counsel, than just being able to give a piece of advice. And what I've tried to do here is list some of those issues that you need to deal with and some of those qualities that you need to have in order to satisfy that commerciality piece, in order to give the best service you can to the firm that you work for. Interestingly, instruction. And so when you take a brief from your firm about a particular issue, it can be quite tricky ensuring that that instruction is sufficiently detailed enough for you to be able to go ahead and act upon it. And I guess that's part of the reason why once upon a time only solicitors were able to brief barristers, was because they were able to sufficiently distill what the brief would be in order for that barrister to act upon it. Thankfully, in our firm, the instructions that I give to our in-house team, I'm able to do it in a way because of the being a barrister, being able to get to the nub of the problem and get them to look at that. But I imagine in some firms it's quite tricky understanding what the brief is and getting to the essence of it. And I imagine much of the discussion that goes on is trying to distill what that instruction is. The second thing is being a strategic thinker, and this is where, as an in-house lawyer, you've got to be more than just somebody who can give advice. And we're fortunate in that our firm, we have spent a lot of time developing staff so that they are very clear about the strategic goals that we need to deliver as an organisation. An in-house lawyer is no different. They need to know what the strategic aims of the organisation are, so that when they're acting in the interests of the organisation, they are also trying to deliver on those strategic aims. It also requires you to be able to respond in such a way as to manage that advice, manage that legal case, so as to be able to deliver on those outcomes. Just offering advice sometimes is not enough. And so I think it's critical these days, if you're going to be in an in-house team, you would need to be a strategic thinker, and you would need to have the training necessarily to be able to understand what that means. The third one, I think, is probably another one of those controversial things that you might object to, but I stick by this. It is important that you're the legal representative for the firm that you're working for, that you are a salesman, a salesperson, being able to advocate and promote the organisation in the best possible way so as to achieve a good commercial outcome. And this is often exhibited when it comes to negotiation. And sometimes, you know, not achieving the best commercial outcome can actually mean that you potentially win more business. In other words, you're giving a bit up so that you can maintain the relationship with the company you're necessarily negotiating with. I think it's critical that you have the key aspects of the organization and you promote that company in pretty much most of the situations that you're involved in. The possible only exception would be when you're in court. Advice. Again, this is probably going to be slightly controversial, but hopefully I can convey what I mean when I say this. Sometimes the advice we receive from external firms is not sensible. It's not commercially right. It's not to say it's not legally right, but sometimes it just doesn't sit comfortably. And there is a sense sometimes with external firms that they're more interested in ensuring that they cover their insurance claims, so they have to go to the nth degree with the advice that they give, rather than what's, you know, practical and what's probable. The advantage of being an in-house lawyer is, because you're a strategic person, because you are a salesperson, because you have understood the instruction, the advice follows that. And that comes again with experience, knowing what parameters to push, what situations you need to kind of be resolute about, or which situations you're prepared to give up on. But it has been my experience that when we've gone for external advice, it's just not been practical. Conflicts. I touched on the general principles and the more specific principles at the start of this talk, but the FCA principles they have another layer placed upon us that are above and beyond our legal duty. And although it is a legal duty because the FCA can enforce that upon us, the idea that if we're pursuing a client for the non-payment of a debt and we take them to court, sometimes we will find that we are required to treat our customers fairly, deal with issues of vulnerability. And I say this carefully, but sometimes our clients get wind of this particular FCA principle and seek to take it to their advantage, and will claim issues of vulnerability so as to avoid having to settle the debt or deal with the debt. We've got no room in that situation, and we have to take account of those disclosed vulnerabilities, and we have to tread carefully, sometimes to our own detriment. And it's how you manage those conflicts where you could push it to the extreme, but the client could ultimately complain to the FCA, and the FCA find that you have acted against the principles of treating a customer fairly, and under the new principles that some of you may be familiar with, consumer duty. So sometimes there are conflicts that we deal with that are tricky to handle, but it's part of the sector that we're in. Resource, knowing when to sub the work out or not, and that's pretty obvious, but again, trying to find those firms who match as best they can with our own social principles and mission principles, and that's quite hard. I was at a conference last week talking about environmental, social and governance, and there were two law firms there who had employed ESG managers to ensure that they could provide to their clients a more balanced and holistic view of delivering legal services. Not every firm's like that. And I was impressed by those particular firms, because to them, it was more than just about giving advice. It was also about giving other outcomes as a law firm. So trying to find the right kind of firm that actually marries with your own social mission, your own social purposes, can be tricky. But, you know, we've been doing this for a while now, and we've got a few that we use. I can give you the names later. Commerciality, managing that commercial imperative with the business objectives. That kind of speaks for itself. How far are you prepared to go in a negotiation on a funding deal to achieve the best price possible? That's always one of those tensions, and it's no different to any other organization. But what is different, and this is where we as an organization that exists for social purposes, doing good comes, if not above, certainly equal to the bottom line imperative. Sometimes we will, in order to achieve the outcomes that we want for our social mission, we will take a hit on pricing and on the deal because it achieves our social mission. We can discuss that later if you like, but we talk about a thing called the triple bottom line. So not only do we want to make a profit, but we also want to achieve a social good. We also want to achieve an environmental good. And if you were to have a look on our website and look at some of the work that we do, everything that we do is defined in terms of the United Nations Social Development Goals. So many of the decisions that we make are driven by our social mission. That's not always the case in organizations, but as I say, we can explore that a bit later in the questions section. The one thing that is interesting, and we have found this over the years, that especially since COVID, it can be quite lonely being an in-house lawyer in a small organization, because you tend to be the one doing everything, and you tend to be working remotely, and you tend to be on your own. I've made a distinct effort with our team to ensure that we keep in touch and we talk about other things, and we look after the well-being of our staff, it's a major issue. The other advantage, though, as we are aware of being in an in-house legal team, you get your sickness covered, you pay whatever happens, you get a pension, and we have just introduced the 9-day fortnight. So instead of working 10 days in a fortnight, we only work the 9 days, and every alternate day, week, you get the Friday off. And we're ultimately moving towards a 4-day week. Part of the reason behind that, we cannot always pay the salaries that some of the bigger organizations want. So we offer other things to support and help that. Along with that message is our professional development plan, and we spend a huge amount of money supporting staff. We paid for our head of the in-house team to do an MBA, and we gave him the time off necessary to do that, partly to help with the strategic thinking, part of that to manage the conflicts and understand the commerciality issues, but partly because they wanted their own personal development, which was a critical part of our organization's ethos. So some of those are the tensions, some of the things that we deal with and manage those tensions. But I want to just talk about a few examples of how we've come across these tensions and how we deal with it, and some of the things that has been encountered in our legal team recently. This one particular example of a tension talks about the vulnerability point that I was mentioning earlier, and this idea of what the FCA require us to do versus what we're entitled to do legally in the court in terms of recoveries, and it relating to a severely disabled personal guarantee holder that we were seeking to recover the debt from. What interestingly transpired is that the person who had taken out the loan from us, who was disabled, had been defrauded by a business partner. So we were faced with the challenge of what do we do in that situation? We're entitled to recover the debt from the person who is disabled and has a PG with us. But is it the right thing to do? And if we were to do that, how does that look in terms of our social mission and the good that we want to choose? So that the view that we've taken is that we don't believe it's appropriate to pursue the individual to through the courts because of their circumstances, even though we're entitled to do that. So that's one example of the tensions that we have. The second tension that we had is touching on this issue about going out to the right firm, and we've just concluded on a £20 million deal with Lloyd's. It's the first time Lloyd's have actually acted in this space, and they used a particular law firm, I won't mention their name, to act for their interests, and we used a law firm that we've used before who understands our sector and understands the work we do. If I told you that the fees charged by the law firm that Lloyd's had employed were, let me just work this one out. Well, it was 280,000 for the law firm that Lloyd's employed, and it was only 15,000 for the law firm we employed. They did exactly the same amount of work. They did exactly the same advice. Really struggled to understand how those two things could be squared up. Thankfully, Lloyd's chose to pick up most of the tab for their own legal fees, so what we ended up paying was much less. But we really struggled to understand that dynamic and how they could justify those fees. Another example of the tensions. As I mentioned, we're a regulated firm, and one of the challenges we had was that our single member, because we're a company limited by guarantee, our single member means that they are our ultimate parent company. But because they're not a regulated firm, they are not allowed to exercise control over us, because a non-regulated firm cannot exercise control over a regulated firm. And that has created a number of legal tensions for us over the years, and how we've managed to square those things off. And has resulted in a number of sometimes challenging issues at board level, when member representatives of the board had different expectations from the non-member representations on the board. And my colleague Julian, who's been managing all of this, has developed a few more grey hairs over the years because of that. So again, challenges when it comes to managing those tensions. And governance, especially when it comes to, we as a social enterprise, we're not allowed to distribute any of our profits to the members. And so it was really interesting to take advice, slightly connected to the earlier point I've made here, take advice from 2 law firms confirming that it is illegal or ultra vires to be able to distribute profits to the member, even though the member had an expectation of receiving that distribution. Again, managing that challenge, and again, has resulted in some interesting board meetings, and a few more grey hairs for my colleague Julian. Anyway, I think I have droned on long enough. So hopefully that has prompted some thoughts, and hopefully I wasn't too controversial. So I will pause there, and if anybody wants to ask me some questions, I'll do my level best to answer them.
Hello, can you hear me?
Yeah, hi.
Hello there, my name is Mohammed Higazi. Thank you very much for the talk. It was actually rather interesting. I had a question about the Lloyds Bank deal. You touched upon it very briefly, but I was actually very curious about the details of exactly where you found the tension you were describing. Is it just with the fees they were charging, or was it a deeper matter than this?
So there were a couple of tensions that existed there. First and foremost, because Lloyds were entering into this space for the first time, their experience of lending to an organisation such as ourselves, who are a social enterprise, so a not-for-profit, that swayed how much they were prepared to adjust their normal terms and conditions against the advice of their law firm, because they wanted to get that deal over the line, and they didn't want it to be so punitive as to put us off. So the tension, I suppose, for us was how far to push back against the advice of this very expensive law firm, when they would say that that was a normal term and condition, but it would have acted in a negative way against our ability to deliver that loan under the normal social terms that we would expect. So I suppose it was the unique nature of the deal that made it quite tricky, and because Lloyds were new to this space.
And do you find when dealing with big banks in general that you have to adjust the normal terms and condition to account for the kind of service you provide, or was it a unique thing to this specific arrangement?
Yeah, well, it's complicated. So we as the social enterprise that we are entitled to certain tax reliefs. And one particular tax relief is called community investment tax relief. We're also entitled to use a British Business Bank guarantee scheme to support the capital that we borrow. So throw all that into the mix, you've got something in the region of 6 parties in discussion in relation to this deal, all trying to get it over the line at the same time, all trying to deliver the same outcomes. So I suppose it was trickier than most normal deals because of those unique qualities. Tax relief, government guarantees, social impact.
And one final question from me, just on the
Yeah.
topic of tax relief, because I was actually going to follow up with that in any event. But I did wonder, when making commercial considerations as to which businesses to invest in or which funds to allocate, does tax relief go into the financial considerations of whether it would be, shall we say, beneficial long term, or is that just incidental?
Interestingly enough, the tax relief that we use, the community investment tax relief, make it very specific how that investment is meant to be used. So we as an organisation have to invest into the 35% most deprived areas of the UK in order to provide the tax relief to our investors. So we have to monitor and maintain and ensure that the investments that we make comply with the terms of the tax relief. So yes.
Thank you very much for answering my questions, and I really love the
very
talk.
specific questions, Mohammed. I commend you for them.
Thank you.
Any other questions? Did anybody find some of the things I said controversial, or did you all agree with them wholeheartedly? I'll take the silence as agree with them wholeheartedly.
Yes, certainly from my perspective, and I finally made it onto camera. Sorry, Stephen. Yeah, I mean, certainly from my point of view, so many things resonated as an in-house lawyer. You know, certainly in terms of you've got to be so much more than a lawyer. I mean, you're a team leader, you're managing people, you're doing strategy, you're trying to really balance commercial aspects with your kind of duty to the court, if you like, as well. And I think that's one of the things that BACFI have been looking at a little bit, is this kind of ethical, kind of unique ethical considerations that employed barristers have, but even more so in the commercial setting than anywhere else, because you are, like you say, you know, you're the face of the organization, especially if you're a senior manager as well. So you're representing the company, you know, you're navigating what you're saying, but also, you know, needing to balance that with your legal advice as well, which, you know, may not be favorable for the company. So it is a tricky area. I think you've got to be something to everyone. And certainly resonates with me as well, the point you were making about advice, because quite often what I find is that in an in-house commercial environment, you'll often have a team of quite senior lawyers anyway, who kind of know the answer because we know where to look for it. And actually kind of what you're looking for is a sense check, someone that really kind of understands your business, that can kind of, you know, say, yes, you're on the right lines, that's correct, you know, there's no issue there, and try and find something practical for you as well. And that, I think that's hard for law firms, because they're just not embedded in your business day to day. And, you know, they've got to learn it, pick it up, especially if you're not using the same firm day after day. So yeah, a lot resonated with me for sure, what you said. That's good. Excellent. Okay, well, I don't think there are any more questions. Stunned them into a stupor. So it was so interesting. Thank you. Really appreciate you giving that time. Really good.
Excellent. All right. Well, unless there's anything else, I think I will stop recording and allow you to go home to your dinners. So lovely to meet you all, and have a pleasant evening.
Thanks,
Thank
Stephen.
you. Cheers. Thank you once again.
Bye.
Bye.